Welcome to Lesson 4. This lesson deals with the rights of the citizen according to the GDPR, the General Data Protection Regulation. We are Pilar, Nicolás, and Mikel Recuero from the University of the Basque Country, the institution that coordinates PANELFIT project. In this presentation, we are going to describe in a general overview the meaning of the faculties that the subject has when his or her personal data are obtained, stored, or used. Remember that the principle of transparency and the subject rights are regulated and guaranteed by the European law in the General Data Protection Regulation. This is the summary of points that we are going to refer to in this presentation. Firstly, some general and common facts related to the data subject rights. And secondly, the content of the different rights: access, rectification, right to be forgotten, portability, object, and right concerning automated individual decision-making. As a general condition, the data subject shall be informed of his or her rights concerning data protection. The information shall be provided in writing or by other means, including where appropriate by electronic means, as a website. When requested by the data subject, the information may be provided orally. Modalities should be provided for facilitating the exercise of the data subject rights. This must include mechanism to request and obtain, free of charge, in particular, access to and rectification or erasure of personal data, and the exercise of the right to object. These rights can be effective, in general, free of charge, and must be satisfied with a time limit. According to the General Data Protection Regulation, the treatment of the data must be carried out based on the principles of fair and transparency. According to these principles, the subject have to be informed about the purposes for which the personal data are processed, about the categories of personal data concerned, about the recipients or categories of recipients to whom the data have been or will be disclosed, about the periods for which the personal data will be stored, or, if not possible, the criteria used to determine that period, about the existence of the right to request rectification, erasure, or restriction of processing the data, about the right to lodge a complaint with a supervisory authority, and about the existence of automated decision-making, including profiling. The information in relation to the processing of personal data should be given to the subject at the time of collection or where the personal data are obtained from another source with a reasonable period depending on the circumstances of the case. However, it is not necessary to impose the obligation to provide information in this last case, where the data subject already possesses the information, where the recording or disclosure of the personal data is expressly laid down by law, or where the provision of information to the data subject proves to be impossible or would involve a disproportionate effort. The latter could in particular be the case where processing is carried out for a given purposes in the public interest, scientific or historical research purposes, or statistical purposes. In that regard, the number of data subjects, the age of the data subject, and any appropriate safeguards adopted should be taken into consideration. The principle of transparency also requires that any information addressed to the public or to the data subject be concise, easily accessible, and easy to understand. Where processing is addressed to a child, should be in such a clear and plain language that the child can easily understand. A data subject should have the right of access to personal data which have been collected concerning him or her, and to exercise that right easily and at reasonable intervals in order to verify the lawfulness of the processing. This includes the right for data subjects to have access to data concerning their health, for example, the data in the medical records. The controller is able to request a specification about the information requested when the process refers to a large quantity of information concerning the data subject. The request to access implies that the controller shall provide a copy of personal data undergoing processing, and, where possible, the controller should be able to provide remote access to a secure system which would provide the data subject with direct access to his or her personal data. The controller should use all reasonable measures to verify the identity of a data subject who requests access, in particular in the context of online services and online identifiers. The data subject shall have the right to obtain from the controller the rectification of inaccurate personal data concerning him or her. Taking into account the purposes of the processing, the data subject shall have the right to have incomplete personal data completed, included by means of providing a supplementary statement. This is an example of this scenario proposed in the European Commission web. The A credit bureau processes information provided by your former landlord, whereby it is stated that you owe him 3 months' rent. You have just won a legal dispute, and his claim for the 3 months' rent was ruled to be unfounded. You may ask the credit bureau to correct the data it holds about you so that you aren't put at a disadvantage in the future when credit requests are proceeded. And this is the end of part 1. Mikel Recuero is going to continue this lesson with part 2.
Hello, my name is Mikel Recuero from the University of the Basque Country. As Pilar has said before, I'm going to continue with the second part of this unit. At this time, we are talking about other rights of the data subject, such as the right to eraser or right to be forgotten, the right to data portability, the right to object, or automated individual decision making, including profiling. First of all, the right to eraser. This right, also known as the right to be forgotten, was initially proclaimed by the Court of Justice of the European Union through the judgment of Mario Costeja against Google Spain. Nowadays, it is expressly located in the Article 17 of the GDPR, which allows the data subject to obtain from the controller the removal of personal data concerning him or her without undue delay. In addition, when the controllers have made the personal data public, for example, publishing it on the internet, they should take reasonable steps, including technical measures, and they shall inform other controllers which are processing such personal data to erase any links, copies, or replications. So, in particular, the right to eraser applies where the personal data are no longer necessary in relation to initial purposes. Second, the data subject withdraws the concept on which the processing was based. The data subject objects. The personal data have been unlawfully processed or obtained. The personal data has to be erased for compliance with a legal obligation. And last one, where the personal data have been collected in relation to information society services. On the contrary, this right does not apply in some cases where a ponderation with other rights or interests has to be made. As a result, the right to eraser does not apply where the processing is necessary for exercising the right of freedom of expression and information, for example, newspapers. for compliance with legal obligations or for the performance of a task carried out in public interest, for example, public records and journals. For reasons of public interest in the area of public health, for example, epidemics and diseases, and for archiving purposes in the public interest and for research purposes, and finally, for the exercise of defense of legal claims. Secondly, the right to data portability. This right is an advanced form of the right of access which Pilar has already explained. The main difference is that the data portability implies the right to receive a copy of the personal data concerning him or her in a structured, commonly used and machine-readable format if the processing is based on the consent or in a contract and if the processing is carried out by automated means. Moreover, the data subject has the right to have her or his personal data transmitted directly from one controller to another, where technically possible. Thirdly, the right to object. It means that the data subject could object on grounds relating to their particular situations to processing of personal data concerning him or her, where that processing, including profiling, is based on the public interest or the legitimate interests of a controller or a third party. The main consequence of this objection is that the controller shall no longer process the personal data unless the controller demonstrates compelling legitimate grounds for processing or for the exercise of legal claims. Finally, we have two special cases related to the exercise of the right to object. First one, where personal data are processed for the purposes of direct marketing. In this situation, the data subject has the right to object to the processing, including profiling, to the extent that is related to such direct marketing. Second one, where the personal data are processed for scientific or historical research purposes. In this case, the data subject has the right to object to the processing unless the processing is necessary for reasons of public interest. Last but not least, we find the right not to be subject to a decision based solely on automated processing which produces legal or similar effects to the data subject. For example, an automatic refusal of an online credit application. This processing includes profiling, in other words, any form of automated processing of personal data evaluating the personal aspects relating to a natural person, in particular to analyze and predict aspects concerning the data subject. However, the GDPR expressly allows this automated individual decision-making with legal or similar effects in three specific situations. First, where the processing is necessary for performance of a contract with the data subject and a data controller. Second, where the processing is authorized by union or member state law, to which the controller is subject. For example, for tax evasion monitoring and prevention purposes. And third, where that processing is based in the data subject explicit consent. In any case, such processing should be subject to suitable safeguards, including specific information to the data subject and the right to obtain human intervention. That's all for now. We expect the lesson has achieved the two main objectives previously proposed: to know what transparency means in relation to data processing and to be aware of data subject rights. Thank you for your attention. You can find more information about the project entering the PANELFIT social network. See you next lesson.